Good morning. Welcome to the Center for Strategic and International Studies. My name is Heather Conley. I'm Senior Vice President here at CSIS that looks after Europe, Eurasian, and Arctic affairs. We are delighted to be in partnership with the Foundation for Defense of Democracy's Center on Sanctions and Illicit Financing to bring you this very timely discussion. I think this is a perfect Halloween conversation. Because there is both trick and treat here. There is the treat of getting the asset recovery. The trick is combating the illicit financing. I knew I could weave that in. So we hope to focus on both trick and treat today. And the real treat we have today is welcoming Ambassador Roberto Balzaretti, who is the head of the Directorate of International Law and serves as the legal advisor to the Swiss Federal Department of Foreign Affairs. And we are delighted to have him. The ambassador has been in New York for the past week and came down for some brief consultations in Washington, and we were very fortunate enough to have him come here and give us an overview of what Switzerland has been working on is by way of reform and focusing on both asset recovery and combating illicit financing. Ambassador Balzaretti has a distinguished career, and throughout his diplomatic career, he has served as Secretary General of the Swiss Federal Department of Foreign Affairs from 2009 to 2012. He's also served as Special Representative of Switzerland to the Human Rights Council and Deputy Permanent Representative to the UN Office in Geneva, and just a series of very distinguished positions throughout his career. After the ambassador gives us some opening remarks, we're then going to welcome a very distinguished panel to have a conversation about the progress being made on both the trick and treat fronts, and then we'll welcome our audience in for a discussion. So with that, again, welcome, and please join me in welcoming Ambassador Roberto Balzaretti to join us for opening remarks. Thank you.
Thank you very much. Good morning to all of you. Thank you for organizing this event and for having me here with you today. I would like, and I will try and give you a very brief overview of what Switzerland has been doing these last 30 years when it comes to what we call the PEPs, the politically exposed persons assets, both in preventing such assets to reach Swiss ground, which wasn't always possible, and in identifying and returning those assets to the countries they were stolen from. The story really starts in 1986. It starts with the fall of former president of the Philippines, Ferdinando Marcos. When the Swiss government learned at that time, by the way, from the Swiss banks having assets of the Marcos family, that there were such assets, and when this became public with a wave of outrage, both in Switzerland and around the world, the Swiss government took the unprecedented decision of freezing Marcos' assets based on the constitutional mandate of the government to safeguard the country's interests. So there were no specific legislation at that time, nor a request for judicial assistance, a specific request from the Philippines government to intervene. So for the first time, it was 1986, these assets were preventively frozen even before the country in question could file a request for their return. And since then, we have continued developing and refining the practices in handling looted assets. And today, I'm jumping 30 years later, we work actively to counter abuse of our financial system by corrupt leaders. PEPs, that you should know, includes heads of states and government, but also senior politicians, government, judicial, military and political party officials, as well as senior executives of state-owned companies or corporations of national importance. And of course, their families and associates. So you see, it's a very large program we have. why do we do that? Well, first of all, for evident ethical and moral reasons. But there are two main reflections I would share with you. The first being that we have, of course, no interest in allowing an abuse of our financial system. We have one of the world leading financial centers, and reputation and integrity are key factors today in global competition. So we don't want this money to be in our banking system. And secondly, we are an important donor state when it comes to international cooperation. We promote good governance and anti-corruption measures in our international efforts, and we want to strengthen the rule of law and eradicate impunity around the world. So it would make no sense, to do that abroad and then to host in Switzerland such assets. And also, these are data from the World Bank. The sums involved are enormous. So the estimate is that 20 to 40 billion every year are stolen by politicians and officials in developing and emerging countries. And so when dictators enrich themselves, they not only steal the money from their countries, they also rob their people of development prospects. We know today that corruption has devastating consequences for a country's society and economy, and we know that there is a clear link between corruption and poverty. So the high level of corruptions usually lead to lower investment and lower growth rate. That's why we do that. Now, we do it keeping in mind two main pillars. The first is that where possible, the assets should not enter the financial sector, well, in our case of Switzerland. But if this happens, and it can still happen unfortunately, that's the second pillar. They should rapidly identified, frozen, if possible preventively frozen, immediately frozen, and if they are criminal in origin, returned to the country of origin. And I come back on that extensively in a while. On prevention, there are today international standards that allow banks and other financial intermediaries to conduct business relationships, business activities with PEPs. It is not forbidden to open a bank account for a president. However, what we have to do is to apply a specific and enhanced due diligence when we do so. Usually, decision of opening a banking account of a politically exposed person is taken at the senior management level of a financial institution. Plus, should there be transactions on such an account that are suspicious, these transactions must be, according to Swiss law, reported immediately to the authorities, to the federal authorities, and the account frozen. So what we do in preventing the money from entering our financial system is first be sure that the banks know the customer, that they know what they are doing, that the decisions are taken at the highest possible level. But should there be suspicious transactions on such accounts, these are referred immediately to the authorities, the account preventively frozen, and then the authorities can decide whether there is ground for opening a criminal investigation in Switzerland or for requesting the country of origin information as to start a legal assistance process. Now, of course, every case is different. Should we come to the point where we freeze the money? And so every case must be dealt specifically. I will give you in a while some examples. One has to be both pragmatic and creative. The key is when dealing with these issues, the cooperation between the state searching for the stolen assets or having frozen the assets and the states they originate from. Very important priority to Switzerland has been to share expertise with other countries and to work closely with experienced nonprofit organizations. We have two main, I have two main in mind. The first one is the International Center for Asset Recovery at the Basel Institute for Governance, and the other important partner is, of course, the Stolen Asset Recovery Initiative, STAR, which is a project of the World Bank, and last but not least, the UN Office on Drugs and Crime in Vienna. Besides technical expertise, these organizations play a significant role in the continuing development of national and international standards. Let me perhaps give you some names of countries. You know, this is public, and so I'm not revealing any secrets. We have returned from 1986, from this infamous Marcos case, about $1.8 billion to the countries of origin of the assets. This is more than any other financial center in the world. We had cases with Peru, with the Philippines, with Nigeria, Nigeria 1 and Nigeria 2, with Angola, with Kazakhstan, both 2, Angola 1, 2, Kazakhstan 1 and 2, Mexico. There are 2 cases ongoing, which are Haiti and precisely the second Nigerian case. I can enter into some details if you wish later on, answering questions. And there are, apart from these, I would say, traditional cases, other assets of politically exposed persons actually frozen in Switzerland, currently frozen in Switzerland. It has to do with Egypt, Tunisia, the Arab Springs uprising, and with the Ukraine. And the amounts we are talking about are sometimes very important. Egypt, the Mubarak and entourage money is about $600 million US. So perhaps 2 examples so that you see how we deal with that. I'll take Kazakhstan and Angola. In Kazakhstan, we have established a trilateral monitoring system with the World Bank and the United States. And this was of course, to support the return of the funds. There were 115 million which were returned and used for projects to benefit disadvantaged young people. An independent foundation was established in Kazakhstan, to which the funds were transferred in installments. So they had to prove that they were using the money properly. And the agreement that was concluded set out the rules that on suspicion of mismanagement, the disbursements of funds could be stopped at any time. So the money has been, as of today, fully restituted. And according to the World Bank's final report, the foundation achieved outstanding results. The funds were used to improve living conditions of about 200,000 Kazakhs, young people. And as a matter of fact, establishing a foundation worked out well. This was a good idea, but it proved also to be administratively very cumbersome. And this is the reason why, you remember I talked about Kazakhstan 1 and Kazakhstan 2. In the second case, on Kazakhstan, where 48 millions were returned, we went another way. We assigned the World Bank directly to return and use the money. In the case of Angola, we concluded bilateral agreements in 2005 and 2012 to return money, funds that had been frozen, blocked in Geneva. In the first case, with 21 millions, funds were used to strengthen agricultural, vocational education and training in Angola, and to fund mine clearance programs. Angola is one of the most heavily mined countries in the world. And the second restitution, which is still ongoing, will fund development projects. So that's what we have done, and we have done it mainly based on non-typical, I would say, legislation, legal basis. After the Arab Springs appraisal and turmoils, where funds were frozen by the government, according to its constitutional competence to do so, our parliament requested that we start thinking on a formal legislation. The idea of having the government intervene based on the constitution is fast, is practical, but if you think of rule of laws, of due process and these things, it's probably not satisfactory enough. So the parliament requested that we draft a legislation, and that we did. The legislation was passed by our parliament in December 2015 and entered into force some months ago on the 1st of July 2016. It's called the Foreign Illicit Assets Act. The idea is precisely to address situations where foreign leaders have, in all probability, that's an important point to stress, enriched themselves by misappropriating assets through corrupt practices, I'm quoting, or other felonies, and by transferring them abroad. So it provides for the possibility for the Swiss authorities to promptly transmit information to the country of origin. So even they don't know that there is money in Switzerland, the Swiss authorities can tell them, listen, we've just blocked some amount, we think that this might interest you. So the law regulates freezing, confiscation, and restitution of the assets, precisely provides for this preventing freezing, even before a request is filed by the country where the funds originate. And it offers solutions in cases where mutual legal assistance is not possible. So you have an administrative freezing and confiscation. You usually, when you deal with these things, you need to have two proceedings going on, one in the originating country, criminal proceeding, corruption, whatever, a request for legal assistance to the country where the funds are, usually, which also open usually a proceeding, and then you cooperate this way. But if there is no legal assistance, it's very difficult to undertake anything, and that's why we decided to have in the law the possibility of first freezing assets in a preventive way, even before a request is filed, and secondly, of conducting administrative proceedings, not criminal proceedings, so that we can confiscate ourselves and restitute the money. The law also provides for technical assistance in cases where there is a mutual legal assistance request, but the country requesting assistance has no sufficient technical means to do so. And very important, it reverses the burden of proof. So the PEP in question, the politically exposed person in question, must explain how he could earn in 3, 4, 5 years in office $300 million US. This law completes the legal arsenal we have. It strengthens coordination in Switzerland, within Switzerland, among the agencies involved, Foreign Affairs, Justice, Attorney General Office, and is, of course, a way out of cases where mutual legal procedures are proven unsuccessful. We also hope that it is also a deterrent for future cases, that it raises awareness, including for financial intermediaries, and that it contributes significantly to the implementation of the United Nations Convention Against Corruption principles. And it completes, as I said, the legal arsenal. So now we have the Constitution. Government can act based on the Constitution. We have a federal act on combating money laundering and financing of terrorism. This is in force since '98. And there you find rules like know your customer rules, no anonymous bank accounts, and so on. You have the Swiss Criminal Code, of course. And I think that you know, but I will repeat it. Banking secrecy does not really exist in Switzerland. There aren't any anonymous banking accounts. There aren't any. And in case of criminal proceedings, banking secrecy is always lifted. And then we have the Federal Act on Mutual Assistance in Criminal Matters. The idea being to have an internal law that allows us to cooperate on mutual legal assistance also with countries with which we don't have a bilateral agreement if certain conditions are met. And now we have this new law. So I try and come to a conclusion. I think that what we have achieved is quite impressive. But I know that there is still work to do. And I know that setbacks are possible. For instance, in the first Abacha case, the Nigeria 1, which we tried to deal with also in cooperation with the World Bank, precisely the World Bank complain of lack of transparency and in budgeting and accounting in Nigeria. Supervision of the use of the money was difficult. In one Angola case, NGOs criticized some of the ways the funds were actually used. So there might be setbacks. And there is a big challenge too. We should not forget, living in countries where the rule of law is so important, is that these processes are, of restitution are long and cumbersome, and especially in complex cases, of state corruption. Even if the conditions for international cooperation are perfect, the process can take several years. Partly because, also in the case of dictators' monies, fundamental rights, such as the freedom of property, cannot be restricted without observing minimum due process rule. And the rule of law, and with it legal certainty, must be respected. This is also why we drafted the legislation. You cannot just return the money overnight. What is possible and necessary, though, is to make the restitution process more efficient, both at national and international level. And for instance, during investigations into membership of a criminal organization, for example, fallen despots must prove that their frozen assets in Switzerland were earned legally. I said it before, this reversal of the burden of proof was first successfully used precisely in the first Abacha case. So we have to take into consideration these lessons learned when structuring restitution process. Each case is unique, but with the right mechanism, we think it is possible to seek transparency and justice in restitution of plundered assets. We have given ourselves the tools to play our role. We are ready to share our significant experience with other countries, specifically regarding repatriation, and we are, of course, interested in identifying and sharing good practices. We did that within the G20 framework. There must be a common strategy, there must be common efforts at international level, and they need political support, and we think that this political support should mainly come from G20 countries. So my last word is partnership. Partnership is key. It is, of course, key in mutual legal assistance. We need to support effective and efficient mutual legal assistance procedures. We need to promote trustful partnership between requesting and requested countries because this offers the best guarantees that the funds, and this is very important, will be used to benefit the people and not be misappropriated once again when we restitute them. Thank you very much for your attention.
Well, thank you. Let me welcome the panelists forward here, and I'll switch over to the seat. For setting and leading the policy dialogue. Sorry, is it not working? Oh, thank you. This is my Halloween trick or treat. We're going to use this microphone. This role, this office, has the lead in setting the policy dialogue related to financial markets integrity. And Emile has been a real thought leader when it comes to providing policy advice to countries on anti-money laundering, combating the financing of terrorism, and asset recovery. When Emile is finished with his remarks, we'll then turn to Mary Butler, who is the chief of the U.S. Department of Justice's Asset Forfeiture and Money Laundering Section. She oversees the department's Kleptocracy Asset Recovery Initiative and has had a long and distinguished career in federal anti-corruption investigations and prosecutions. She's served for over 16 years in the U.S. Attorney's Office in Miami, as well as in the Public Integrity Section in Washington. And from 2011 to 2014, she worked in Ukraine as a resident legal advisor. I'm sure you have great stories to tell us, Mary, about that. And finally, delighted to introduce Juan Zarate. Juan, we share Juan. Juan is the chairman and senior counselor of the Foundation for Defense of Democracy's Center on Sanctions and Illicit Finance, and he is also a senior advisor here at CSIS. Juan is extremely busy. He is chairman and co-founder of the Financial Integrity Network. He serves as a senior national security analyst for CBS News and is a visiting lecturer of law at Harvard Law School. What do you do in your spare time, Juan? Juan has the distinction of being the first ever Assistant Secretary of Treasury for terrorist financing and financial crimes, so a trailblazer on many fronts. So I'm just going to check with my colleagues. Do we have to use this microphone for the whole panel, or is everybody okay? For right now, okay. This is when those goblins are in our text. So I'm going to hand this microphone all the way down to Emile. You feel like a rock star when you have this microphone. So here you go. What's happening is we have a live stream, and it's not picking up for the live stream. So if you may, I'm going to pass this down.
It's like a game show.
Thank you, Heather, and good morning, everyone. And thank you for inviting the Stolen Asset Recovery Initiative and the World Bank to be here today. It's interesting how the environment on asset recovery and altogether AML, CFT, anti-money laundering, combating the financing of terrorism has changed in the last, since the financial crisis, I would say. From being very much a wonkish topic that a few policy advisors in a floor somewhere in the Ministry of Finance would work on, and using language that was impenetrable to the outsider, it's really become so much more mainstream. The other day I was looking at the front page of the FT, and I saw just on the front page 3 articles that either directly or indirectly related to anti-money laundering, corruption, financing of terrorism. It's extraordinary how this topic, with whether it's the financial crisis, the anger about tax evasion, the Arab Spring, the G20 push, the G7 push on beneficial ownership, it's become part of our daily conversation. And the Swiss were certainly very much trailblazers when it comes to asset recovery. Really, the first country to take this topic seriously. And I just want to reflect on a couple of points that the ambassador made. The first point, I think it was very interesting. What you said is, when you froze in 1986 the assets of Marcos, you used a very general clause in your constitution that just said, you need to do whatever is in the interest of the country. And I think that demonstrates that if you use, something like that, it sort of demonstrates the principle that we often, as the Stolen Asset Recovery Initiative, have with countries is, if there is political will, you will find a legal way to do it. Of course, ultimately you want to make sure that principle gets better enshrined in law, and that's why you adopted your law earlier this year. But I think that first principle, that if a country really wants to go after a problem, it can do so. It can find the ways to do so. I think we've often seen that, and sometimes not having perfect laws is just used as an excuse not to act. And I think that's an important point. That said, of course, laws are very important. So on the preventive side, again, I commend Switzerland and some other countries that did it in the wake of the Arab Spring for the adoption of some sort of preventive system that allows for the immediate freezing on the basis, just an administrative freeze before mutual legal assistance channels, which always take a very long time, have kicked in. To have such a system that allows immediate reaction, and Switzerland, of course, did that in the wake of the Arab Spring. The EU did it as well, but they used their terrorist financing administrative freeze, so they slightly had to stretch the boundaries of the law. But again, it shows the principle, where there is the will, you will find a way to do it. Canada did something similar. So that, as an idea, I think, there've been now some examples, and I hope that around the world other countries will follow suit and institute those types of legislation, those types of provision. Another thing on the preventive side and on the legal side that I think is important, and the ambassador alluded to it briefly, is the customer due diligence rules that are applied by banks, and the obligations that are incumbent upon banks to scrutinize any funds, certainly if they are funds that are owned directly or indirectly by politically exposed persons. I think that, as a rule, is now generally accepted across the world. Sorry, are you pointing to me? Oh, this one, we're back on? We're good? Okay, good. On banks, I think we've sort of internationally, there are very few banks that I know of, or very few countries that I know of, that are still fighting that on the banking side. I think, however, if you look at what is known as the trust and company service providers, the lawyers and accountants that also need to conduct some sort of diligence of the clients for whom they are establishing a company or for whom they are setting up some sort of structure, there the international experience is distinctly less homogeneous, and there is a clear divide between some countries that have taken, the international standard on this, the FATF recommendations on this, and said, yes, we are going to implement customer due diligence for lawyers and accountants and make sure that they apply them, and other countries that have taken a more standoffish approach on that. And I think where we really need to get, the principle we really need to establish is there's no such thing as a neutral service provider who simply, I just provide this service and it doesn't matter who I'm providing that to, that's none of my business. I can go ahead as, just with that service. I don't need to know anything more. That principle needs to be debunked, and I think that is where, internationally speaking, there is still a lot to be done. Another legal point that the ambassador mentioned, and that we're slowly seeing gaining traction internationally, is the illicit enrichment, or some form of the shifting of the burden of proof from the prosecuting or investigating authorities having to prove in great detail what the illicit origin is, to a presumption that under certain circumstances, as they are set out also in the Swiss law, that under certain circumstances it is not the investigative or the prosecutorial authority that needs to prove the illicit origin, but it is rather the politically exposed person in question who needs to demonstrate the licit origin. And I think it's in the United Nations Convention Against Corruption as a countries should consider. So it's not an international legal obligation. It's there as a should consider, but I think more and more countries are considering and starting to implement that. It was up until now, I think you saw more illicit wealth, illicit enrichment provisions in developing countries. I think now slowly but surely Australia, the UK, of course Switzerland, and others are starting to adopt similar provisions, and I think that is a very effective tool in trying to stem the flows and the proceeds of corruption. But all that said, if the numbers are, even at the low end of the scale, if they are 20 billion a year, and if you see what has ultimately been recovered, it is only a fraction of that. So clearly, there is more work to be done. And for that, I want to very much join the ambassador in his plea for international partnerships and technical assistance. I think there's been little attention in the discussions of your law. I mean, the discussions of your law have been mainly focused on the legal sides of it. Of course, what has changed as far as the mutual legal assistance is concerned. But there is also a provision in there on Switzerland's offering technical assistance to countries that are in need of that. And we at the Stolen Asset Recovery Initiative have seen that and continue to see that on a daily basis. Countries want, sometimes there are problems with whether the country really wants to commit, but in a lot of cases the countries do want to go after the funds, but they just do not know how to conduct a financial investigation. They don't have the expertise. They don't know what you will find if you go into a bank. What do bank account documents, opening documents look like? What does a bank have? How do you then use that in a court of law? How do you prove things? How do you reach out to other countries? What do you ask them for? All those sort of questions are new to a lot of countries. And so on that front, we, the International Center for Asset Recovery, US DOJ, the Swiss as well, offer technical assistance, and preferably by sending someone there who simply sits with whoever it is, the investigative authorities in the requesting country, to help them build that capacity in place. And I think that is one of the most important things that we can do is to build that capacity there. Finally, a small word on the role of society, which I think hasn't been discussed at great length, I think, in Ukraine, but Mary, I'm sure you'll be able to say much more about that. You saw civil society being very active in actually mounting cases. There have been some cases in Europe where the civil society organization in question was found to have standing before a court of law to go after corruption. So there is some progress internationally, but I think a lot more there can be done, both on civil society actually taking action, but also possibly civil society as recipient of flow of illicit proceeds. If you don't want to return it to a government where you have a fear that it will be re-corrupted, so to speak, then civil society might be an option there. So I will leave my comments there. Thank you very much.
Thank you, that was great. Mary.
Well, I also want to thank you for inviting me and giving me the chance to talk about the department's work of trying to prevent the United States from being a safe haven for corruption proceeds. It's not a new commitment by the United States, but the Kleptocracy Asset Recovery Initiative is a fairly new commitment of concentrated resources. The department in 2010 decided to create this initiative and to staff it with prosecutors who would work exclusively on these types of cases, and over time recognized that we needed indeed more prosecutors and that we needed also specialized investigators and more of them. In the audience is one of the founding mothers from the FBI of this Kleptocracy Asset Recovery Initiative, Deb LaPravat. And much credit goes to her for helping to establish a lot of our international partners around the world in this type of work, and also to beat the drum about the need for more resources. We have now 16 lawyers in the initiative working full-time on this, and we just got authority to hire 7 additional lawyers. We now have an international corruption unit within the FBI focused both on FCPA and kleptocracy cases. And we have a little over $2.8 billion in assets restrained that are the subject of publicly filed cases at the moment. One of the largest and most recent is our case involving embezzlement from the Malaysian Sovereign Wealth Fund, 1MDB. But we also have some money restrained that belonged to the Marcos. We have $40 million associated with the Marcos money. But we also have some smaller cases. We have $2 million restrained for Honduras. And for us, it's a very important case because Honduras is making some big strides in tackling its own corruption problem, and we want to be supportive where we can. Of course, our success is highly dependent on our work with our international partners. We need their bank records, we need the sources of information that they have, and this includes countries like Switzerland, who's been a good partner of ours for many years, but also, as Emil was saying, we're highly dependent for our success in the capacity of the countries where the corruption occurred to give us the evidence of what is exactly the illegal source of the money. And I can explain a little bit more, although it's more painful than interesting, maybe, for people who aren't doing this work. We don't have a law like the Swiss, so we don't have the ability to proactively freeze assets, and we don't have a law that allows burden shifting so that the kleptocrat has to establish that the source of the money is clean. We have to use our traditional civil forfeiture and criminal forfeiture laws, which don't allow for burden shifting and don't allow for proactive freezing based on what you might say is status or the obvious, that it's not possible to have earned these enormous sums of money legitimately. So we are highly dependent on the ability to link assets to specific foreign corruption, and then to prove that either by the criminal standard of beyond a reasonable doubt or the civil standard of preponderance of the evidence, and come out the other side and then deal with the challenge of repatriation, which the ambassador spoke about so eloquently. One of the areas we hope to be most successful is in working in coordination with our FCPA prosecutors. FCPA prosecutors prosecute bribe payers. In that process, they develop information about who the bribes were paid to. And in theory, the Kleptocracy Initiative then would go in and scoop up the bribes and prosecute to the extent possible the officials and the money launderers who participated in that process. But not all of our cases are actually linked to FCPA matters. We do have one which involves $850 million paid to an Uzbek government official by some telecommunications companies. But most of our cases are freestanding. We got information about the corruption, we developed it, we got to a point where we had to decide if we were ever going to get jurisdiction over the people or whether we were simply going to go after the assets. And so civil forfeiture is the tool that we use most often. And civil forfeiture is the kind of litigation that generates these crazy case captions like U.S. versus one red Ferrari, or U.S. versus a whole lot of money in a Julius Baer bank account, because the focus is the assets. We prove that
or HSBC.
Yeah, or HSBC. That's right. That's right. That's right. We focus on the assets, and we dirty up the assets, and then we attempt to respond to any claims filed by people who think that they have an interest in the proceeds. And then if we're successful, we get a judgment which gives us title to those assets. And then our commitment is to repatriate them in the most transparent and accountable way possible. Just a word about the challenge of trying to make cases in countries where corruption is systemic. I did spend 3 years in Ukraine before, during, and after the Dignity Revolution, and I can tell you that there's nothing like living in a systematically corrupt country for a corruption prosecutor to drive home what the everyday reality is of corruption, from everything from school books and grades to medicine to road police. I mean, it's an experience which is hard to imagine until you actually live there. But I think one of the other things we see in Ukraine and some other countries is frequently the criminal justice system wasn't used to investigate and prosecute people for money laundering or for corruption crimes. Frequently, it was used to develop evidence for some corrupt purpose, maybe for extortion, or maybe just for intelligence purposes, or maybe not at all, depending on people's protected status within the community. At the same time, investigators who weren't allowed to do their job are now being expected to do it, and to do it in a highly complicated area, and to do it very quickly. And so this is like asking people to repair a Formula One race car when they've been fixing bicycles. This is like, can't be understated, the degree of difficulty that's involved, and that's why people like the World Bank STAR Initiative, ICAR, and to some extent the US Department of Justice's OPDAT program, which is State Department funded, play an important role in capacity building. Financial investigations training is critical. It's a critical need in our own country, and we spend a lot of resources training domestic investigators on these skills. We need to do it abroad. And again, if we're providing that skill now and asking them to go back to work on historical cases, this means this process is a very lengthy and time-consuming process. So despite the challenges, I don't want you to think for a minute that my 23 lawyers aren't charged up to do everything they possibly can. It's some of the most gratifying work for a prosecutor to be able to deprive a kleptocrat who has all the advantages in the world to make money legally, to deprive them of these resources and give them back to the people harmed by the corruption.
Mary, thank you so much. That was extremely informative. Juan, why don't you, like I say, you're the cleanup position. You get to tie this all together, and then we'll start to question.
I get to ride the intellectual wake of everyone here. Well, Heather, thank you for having me. It's really an honor to be up here with real professionals who are working on these kleptocracy and illicit finance issues on a daily basis, and great to see the ambassador take his new role and to hear his remarks. This has become a bit of a tradition for us. This is now, I think, the third asset recovery kleptocracy panel that we've hosted at CSIS. I think some of us have done this before, and with the ambassador's predecessor, Valentin Zellweger, who's been a real champion on these issues for a number of years. And I've been honored to work with the Swiss government, government of Liechtenstein, other banking centers over the years on these issues. So really privileged to be here. Thank you. Let me just reflect on a couple of things, and part of this goes back to Emil's point about just the enormous evolution that we've seen over the last 10 years on these issues. Because I'm thinking back to my initial exposure on these issues, which was when I was at the Treasury Department in the early 2000s, and in the wake of the invasion of Iraq, we began the effort to hunt Saddam Hussein's assets. In a very reactive post-invasion context, we began to try to hunt where he and his family members had hidden money around the world. And it became quite evident then, even though we found some success, that the system was not well set up to be preventative. We were in reactive mode, and all of the cases before, the Nigerian cases, the Philippines case, the Peruvian case, all tended to be reactive after the fall of a regime, after the fact, after an invasion, after political winds had shifted. And I think there was a realization for a lot of us, and I think with the World Bank initially, with the STAR Initiative, then with the Department of Justice, and then in the Bush administration with the establishment of the Kleptocracy Initiative in 2006, that we really needed to shift the paradigm, that this needed to be preventative, that we needed to see a partnership between the banking centers and developing economies, and that this couldn't simply be a reactive function globally, because so much of these corruptive pilfering of assets was so dangerous and damaging, not only to national security, but also to development. And so there was a real appreciation for the fact that we needed to change course. And in all honesty, the Swiss government has taken a leadership role in this. What the ambassador has laid out in terms of Swiss law, not to mention Swiss action, especially in the wake of the Arab Spring, has really been groundbreaking for a banking center that had been known for bank secrecy, but has now become known for very aggressive actions in trying to ferret out where illicit proceeds have found their way into the banking system. So let me just reflect on a couple of key developments, some of which Mary also talked about. The fact that we now have systems and legal structures that are intended not only to be preventative, but to be deterrents. And I think that this is an important point, that the banking centers around the world, in the United States now, especially with the enforcement actions, is trying to increase awareness, is not only trying to prevent these illicit assets from finding their way into the banking centers, but they're trying to actually create deterrent effects so that leadership no longer finds safe haven and no longer sees it as an easy recourse to pilfer money and to place it into banking centers in the developed world. And I think that notion of deterrence has been a very important part of the enforcement actions and the laws that have been described up here. A second shift has been this movement toward administrative actions, not simply relying on criminal cases to be able to then take action preventatively. And in this regard, the burden shifting that Switzerland has really pioneered is critical, because the question really should be to leaders around the world that have access to hundreds of millions of dollars, should be prove your source of wealth and source of funds, which is a core question in the anti-money laundering world, core to this question of transparency and accountability. And so what we've seen, especially with the Swiss law and with some of the practices around the world, is to begin to shift the burden to say, look, if you place $1 billion into accounts or into products in a banking center, you do have to describe and explain both before and after what those source of funds should be. And frankly, that shouldn't even be dependent on whether or not there's a criminal investigation in your home country, because there are so many limitations to what that looks like. And so that shift, that burden shifting, that legal reframing is a really important part of this effort. A final point, which the World Bank should take a great deal of credit for, is this idea of responsible repatriation. Because so much of the hindrance of cooperation and capacity building and political will has been this, and we saw this in the Nigerian case, the Abacha case in particular, that why are we going to expend all these resources and energy when if we send the money back, it's simply going to be fed back into a corrupt system that will be misused and misappropriated again? And so the idea of having funds that are earmarked and dedicated and actually managed externally for purposes within a country become very important. This has been a sticking point, for example, in the Arab Spring countries, where the issue of asset repatriation is tied very neatly to issues of sovereignty, and there hasn't been a willingness on the part of the Egyptians or the Tunisians or the Libyans, for example, cases I know well from the private sector, a willingness on their part to allow the international community to play that role. But in not allowing that to happen, they have, I think, short-circuited what could have been much more robust international cooperation. For example, if you had the World Bank administering the repatriated funds into Tunisia or into Egypt or into Libya, there would be much greater international confidence as to what would happen with those funds. And so that shift is an important one, and one that I think the World Bank should continue to push. Now, I think there's some major challenges moving forward, and as Emil said, what's fascinating is geopolitically, and in terms of all the issues of anti-money laundering and countering the financing of terrorism, these issues are now central to the debate. And so whether it's Honduras or the Philippines or Russia, Ukraine, any country or issue around the world, the Arab Spring countries, These questions of transparency, accountability, asset recovery are central, but there are still some major challenges. The first is, how do we define not just politically exposed persons, which includes high-order friends and family, so to speak, but how do we think about the mechanics of asset recovery around those friends and family? One of the things I discovered both in the Iraq context as well as in the North African context when I was in the private sector trying to assist in some of these issues is that these leaders have learned quite adeptly that they can't simply put assets in their name into a Swiss bank account or into an American bank account. It's not going to work. And so they've learned how to layer, and we saw this with the Panama Papers, for example, with some of those cases, for example, the Assad regime in Syria. They use their family members to run certain parts of the business and business operations, which then allows money to filter out. And in the cases that I've been a part of in terms of asset recovery, you have networks of businesses and interests that align around those centers of gravity, around the political leadership. And so the question becomes, how far can you then apply some of these very aggressive, good, and important tools and the presumptions that are built into them to people like the sons or the daughters or the cousins or the business associates or the right-hand men or women of the key leaders? That is a really interesting and important question, and I think we've dealt with it in pieces and parts, but there hasn't been a sort of a deep policy debate around those issues. The second is this ongoing international debate, and certainly here in the United States, around requiring ultimate beneficial ownership to be understood and to be registered in some way. This is a major debate in the Financial Action Task Force, probably a source of criticism for the mutual assessment of the U.S. system, which has just happened internationally. We haven't seen the results of it, but it's likely to be a source of some criticism of the U.S. system. But we cannot know where leaders are putting assets around the world if they are able to create corporate structures and hide the ultimate beneficial ownership of those structures. So that systemic question drives right into the heart of whether or not we can be effective in looking for these assets in key banking centers. Finally, I think there's an issue of both capacity and will on both sides of this equation. And one of the things we've repeatedly heard in these debates is a lot of recriminations from developing countries about why the banking centers around the world haven't done more to prevent these things from happening, and a lot of concerns from the developed world saying, look, you have to have the capacity and will to do some of these things and accept the support of the Swiss or the Americans or the World Bank. There is still a lot of mistrust in the levels of cooperation. And I think what Switzerland has done, what banking centers around the world have to do, is to be much more proactive, as they have tried to be, to drive these issues. Because I think we have to break the Gordian knot of mistrust between North and South, between developed and developing countries in this regard. And maybe that's the final thing I'll say in my experience, that at the end of the day, the success of the ability to prevent illicit assets from finding their way into banking centers, or the ability to trace them effectively or to enforce, boils down to will. Is there political will to do things, be it through a constitutional mandate, new laws, laws that have to be adapted to a situation? But at the end of the day, it's a question of will on the part of all the actors. And I would say the major failings in the system have been around the fact that there hasn't been a willingness on the part of actors, including in those that have suffered at the hands of corrupt dictators like Gaddafi, to actually take hard decisions. And part of that is the endemic corruption of some of these countries and some of these systems. And that has to be a part of the solution. So I'm very pleased to be here, Heather, and really honored to be a part of this panel. Thank you.
Juan, thank you so much. Terrific, terrific presentations. What I thought I'd do is we'll work down the line, and Ambassador, just give you a few moments to reflect on any of the conversation and discourse that our panelists provided. But for a specific question to you, have you seen with the implementation of the new legal framework, Has there been harm to the Swiss banking and financial sector because of this greater transparency, or has it been sort of a neutral issue? I'd welcome your reflections on that. Mary, I mean, is there thinking in the U.S.? It seems our system is extremely complicated. The burden is on us. Has there been thinking about how to create more in the framework of the Swiss thinking of how to do that burden shifting? And then really, Juan, Emile, you both reminded me of how powerful this is, and that's why we put the title of the event, This New Foreign Policy Frontier, because it seems to me this is now, not just the FT's coverage of it, is becoming a real question about governance and leadership in the 21st century. Some states appear to be using this as a tool of statecraft. Others are trying to fight against it with some success, sometimes not. Help us understand, you know, the impact of this when countries get it right and start to get it right, the impact of when they continue to succumb to this. And I'm just wondering, all four of the panelists, what was the impact of the Panama Papers in your work? Was it a help? Was it a hindrance? And what we're seeing is investigative journalism plays an enormous role in uncovering this, yet we see more and more regimes suppressing that exact foundation of trying to investigate that. So welcome your reflections, and then after that we'll ask our audience to weigh in. So Ambassador, please, why don't I have you begin?
Thank you very much. Well, the new legislation just entered into force, so it's not something that is showing its effects, its direct effects right now, on one hand. But on the other, it's a kind of codification of a practice we have been conducting this last year. So I really think that the changes began after the Marcos affair, and then the many, unfortunately, many others, to settle in with the financial sector in Switzerland, that it was not worth, you know, hosting this money, because the risk for the reputation, and by the way, you know, the possibility, the opportunities of making good business with this money was near to nil. So these were the changes. The law, the legislation codifies all that, and it has been, you know, discussed here now at length. Another issue which has changed, I think, the situation enormously are sanctions by the international community. So you have UN sanctions, sanctions of the European Union, American sanctions. I haven't talked about that because it would lead us far from the direct subject of this morning, but it is linked to some extent. We also have a legislation on adopting sanctions, which says that we will implement sanctions. Well, we can do it ourselves, but you know, the power of Switzerland is not the power of the US or the UN. We implement sanctions of UN.
Oops. Someone's
Welcome.
phone just rang.
Now, implement international sanctions also of important partner of Switzerland. So we have the possibility of implementing, for instance, you know, American sanctions, and to freeze assets of persons listed by the American government or by the UN. This was also an important change, you know, in the international environment, and some of the measures we have taken were based on sanctions and not on what we have been discussing these days. But if you take all that as a whole, I think that the awareness of everyone in Switzerland, you know, was raised these last 20 years enormously. Now, of course, there are challenges. Of course, Juan mentioned that this applies to the financial system, financial intermediary stricto sensu. So lawyers are actually not covered by that. But you know, if you're a lawyer and you're administrating some money, you have to go through a bank sooner or later. So and what the banks started 25, 30 years ago in self-regulating themselves, in providing themselves for enhanced due diligence, and then slowly, you know, transforming these self-regulatory norms in laws will probably happen to the non-financial sector in the future. It's a matter of time. It's a matter of working on that and insisting on that. I think I'll keep it by that.
Thank you, Mary.
First, I echo the comments by my colleagues about the contribution that to preventing illicit funds from being brought into the United States coming from the banking enforcement actions. The asset forfeiture and money laundering section has a bank integrity unit, and by themselves and together with some U.S. attorneys' offices and sometimes working with state regulators, especially in New York, they have brought some major actions against banks for failure to have the kinds of programs that would identify money laundering going on in their banks, and at the same time sanctioning it when it's knowingly happened. And this is a tremendous incentive deterrence program, and it complements well the Kleptocracy Initiative work. In terms of the Panama Papers and the role of investigative journalism, I should first say that knowing who the beneficial owners of assets are is extremely important, but it's only one piece. We still have to find what the bribery transaction was that generated those illegal proceeds. It's a little easier in the embezzlement context, but we got to find that too. What was who embezzled the money, and then where did it go? But obviously, any help we can get in identifying the assets is important. Whether or not we could have done more. We have benefited by other countries who've been further ahead than the United States in their beneficial ownership disclosure rules and regulations and statutes. I think the FATF will say, as Juan predicts, that we're way behind in our own acknowledgement of that problem and dealing with it in the United States. There's legislation proposed now, as well as some Treasury regulations, rulemaking going on to try to address the problem, but we're behind the curve on that score. We don't, as I said before, we don't have this Swiss model of preventive freezing and then burden shifting to allow us to repatriate assets, to terminate the ownership interest of the kleptocrat and then repatriate assets. And I don't see any movement on that score in the United States in the near future. We can be hopeful, but I think the reality is that even now, our whole asset forfeiture regime is under some serious scrutiny by our Congress and may well be cut back to a certain extent. There are obviously a lot of people working on this issue, but in any case, I don't see us able to follow the Swiss model anytime soon. With regard to the role of investigative journalism in general, though, I don't think there's any question that journalists do a tremendous service in identifying criminal activity that generated a lot of money. And many times their ability to do this goes beyond our ability to see it. And so that is critically important. I think in Ukraine, we've seen some amazing work by journalists who open doors that we then can walk through. But journalists don't have access to financial records for the most part, unless somebody throws them over the transom to them. I know that's old school talk, but I mean, unless somebody secretively provides them to the journalists. So they're a huge start for our investigations to the extent that they have sources who are willing to provide information to them with anonymity promises, which are things that in law enforcement we're not always able to give. They provide a tremendous role. But again, it's the front end of the picture, and we need to do what we can to support them in opening those doors for us.
Heather, with your indulgence, I'm going to hit a couple of the issues you've asked about. Because the Panama Papers, I think, was a watershed event. Not because it revealed anything new that those of us who've been in the field and the audience and those who follow these issues weren't aware of, but it accelerated the awareness and the debate around the necessity for transparency in the financial system and frankly forces a debate that we're still having around what we mean about transparency. Because some degree of financial privacy is important, right? You look at autocratic regimes' attempts to influence and get at dissidents and others. You don't want necessarily people's every movement financially to be exposed to all actors. At the same time, you can't have dark corners of the system that are structured in ways to actually hide and layer where assets come from. And the Panama Papers reveal very clearly that though some of that activity may have been legitimate, some of it was clearly intended to evade taxes, to evade sanctions in the case of the Assad regime, to move money and to layer it, for example, on the part of the Gaddafi regime. So it gave light and momentum and was a catalyst for this debate about how transparent should the system be. And that therefore has created additional pressure, for example, in the private banking sector, not just in Switzerland, but around the world, with major Western banking services that provide private banking services for high net worth individuals. The question is, what level of transparency reporting should there be, and to whom is that information provided? And I think those are really important fundamental questions which the Panama Papers has really accelerated, and now the Bahama Papers too, right? So we're likely to see more of this. On the issue of U.S. enforcement, one thing that's been interesting, and as I've traveled around the world and talked about these issues, you constantly get an allergic reaction to U.S. enforcement. You saw this in the FIFA case. You know, the question of, why does the U.S. even care about soccer? Why are you even bringing a corruption case tied to soccer? And of course, this must be some nefarious retribution because the U.S. didn't get the soccer bid and Qatar did, which undercuts the idea that we care about soccer, because I don't think anyone really calculates that, and we're not that organized anyway. So in any event, the role of enforcement in this on issues that are internationally accepted norms is a very important issue. And frankly, in the FIFA case, the U.S. and Switzerland cooperated very closely. And the Swiss Attorney General, someone with whom I've worked, a man with great integrity, is driving these investigations now from a Swiss perspective. These cases are really important. One, MDB, Mary's mentioned this, hugely important case out of Malaysia. The U.S. has now frozen over $1 billion in assets and is exposing a lot of the structuring and the networks. That's incredibly important. And so what we do in enforcement, whether it's from the U.S. perspective, the Swiss perspective, or otherwise, is a very important driver for these issues. And I would commend Mary and her team for the work they've done. A final kind of category of points, in part because I want to challenge the ambassador, because with typical Swiss humility, I think he's underplaying the power of what Switzerland does and can do. Because I think we're now in a new environment where what key and legitimate banking centers do in terms of their laws, their preventative actions, what they actually articulate, a speech like this morning's, actually moves what others do in the system, what banks internationally have to pay attention to, not just Swiss banks, but American banks, British banks, and others. Dictates to a certain extent what other banking centers are willing to do or may have to do. What does Singapore do in the wake of the new Swiss law? What does Dubai do in the wake of the new Swiss law? So all of this matters quite a bit. And I think the Swiss in particular, given their deep appreciation for the importance of the reputation and strength of their banking center, is really a key player in this regard. Two quick ideas that I think are important. It gets to the question you posed to Emil and to me. I think one issue that we haven't fully grappled with is, can we do preventative asset chases? Again, we've tended to do asset chases after the fact. One of the things I've argued for some time now with respect to sanctioned regimes, for example, in the case of Iran at the height of the pressure on Iran, or even with Russia to a certain extent, is shouldn't we be doing more to preventatively find where some of these leaders are placing and moving their money before there's regime change or before there's some political shift, in part because it matters. It matters that we are preventing this from the get-go, but it also matters in terms of the effectiveness of sanctions. Shouldn't we know where Putin perhaps keeps his assets? And in fact, one of the arguments in the wake of the cyber hacks that are alleged to be coming from Moscow is whether or not we can accelerate the hunt for Putin's assets and how he has layered it, and whether or not some of that should be made public. So to your point, does some of that information emerge through the media and otherwise, and does that impact in the context of Russia? So I think that's a really interesting set of questions, because it dovetails the issues of sanctions, geopolitical crisis, and asset recovery in a very interesting and neat way.
Yes, on the Panama Papers, I completely agree, Juan, with you that there's very little new in there. I mean, there's very little that really should surprise anyone who's been dealing with money laundering for a long time. Yet it is important because, again, it was one of those moments that, is that why, for instance, lawyers are so important in this whole debate? A lot of people, myself included, in this field have been trying for a long time to make the point that financial institutions is one thing, service providers is another, and much more progress was to be made. And I think the Panama Papers, if anything, demonstrated that. I'm not sure whether the law firm, in fact, was contravening the law in its own country, or whether it was indeed allowed, as I said earlier, to provide services in a neutral way, saying, I'm just setting up a company and that's all I do, and what's wrong with setting up a company? So it goes back to that point. On your point, Mary, it does very much sound that for a lot of people, beneficial ownership has become the be-all and end-all of asset recovery, and it is but one part of the puzzle. And I think certainly policymakers are sometimes inclined to forget that and think that if you somehow have a beneficial ownership registry, then all your ills will be done. So I agree with you that there is more work to be done after that. Thing we haven't really discussed, and I won't mention in great detail, but is also the pressure that's been coming from the tax arena on illicit financial flows and beneficial ownership, and how that has played into this. You asked, Heather, what's the price of getting it wrong? Juan already talked about sanctions, but there is the blacklisting that takes place within the Financial Action Task Force. The EU has just announced that it will be setting up basically a blacklist for tax havens. And from personal experience, countries really do care whether they end up on that list, and they will make every effort, certainly on the legislative front. Implementation tends to be another thing, but certainly on the legislative front, they'll make every effort to make sure that they stay off those lists, and they tend to be very, very aware, and that tends to be, at ministerial level. So I do think countries, particularly into smaller international financial centers that are really dependent on their non-resident client base for the economy, they're very aware, and they are certainly doing their utmost to make sure they don't end up on such lists. I think worrying about corruption proceeds started a while back. I think since maybe 3 or 4 years, most international financial centers are also seriously concerned about somehow being involved in tax evasion or that side of things. So I think it's really shifted from just a concern about criminal funds to also anything that comes from tax. And countries that get it right, I think there was a very good example just of the Arab Spring. Both FINMA, the Swiss regulator, and the FSA, as it then still was, the Financial Services Authority in the UK, came out with a report on how well their banks were implementing politically exposed persons obligations. And they were very critical of their own banking sectors. Without naming banks specifically, they gave percentages of what banks were not doing. I think that sort of exercise was extremely healthy and salutary, and good, and all credit to them, to both supervisors, that they put this out, and that they were fiercely self-critical, and it shows that however much we hope that progress has been made, there's still a lot to be done. Thank you.
Wonderful. Well, we have very short time, so I wonder if we could just bundle a few questions and then have our panelists respond. Oh, we have great questions. So we'll take the three on this side, and if you could please identify yourself and your affiliation and make the questions extremely brief. Thank you.
I will try. Thank you. Taylor Winkleman. I'm a foreign policy advisor in Senator Markey's office. And my question is for really everybody. As we crack down, as the Swiss have done, and we increase the risk for these PEPs to bank with them, they're naturally going to go someplace else or attempt a different avenue. And I believe that this gives us an opportunity to identify what those avenues might be and proactively prepare to shut them down. So I'm sorry, this is not the easiest question, but do we have any idea of what those avenues might be in the future, and what actions can we take now to prepare for them?
Thank you. I'm Jenna Liffitz with the Weekly Standard. I had a question more related to the combating illicit financing rather than the asset recovery. So last week, the State Department refused to rule out additional cash payments to Iran. That's something that Justice Department officials have reportedly objected to in the past. And the last round of cash payments was criticized heavily for undermining illicit finance sanctions. So I'm wondering whether more concessions could be made without everything falling apart.
You're going to take that one.
Yes, all easy questions. Hello, my name is Dirk Wouters, Belgian Embassy here in Washington. Question of legal nature, maybe directed to Mary Butler, if you allow me, thank you. Or maybe also to Ambassador Balzaretti. If in the American system or in the Swiss system, you have a judgment that produces a title to recover foreign assets, would that judgment always have precedence over international, regional, or national legislation freezing those assets? And I'm talking about my question, of course, is linked to sanction regime, but as we are increasing the number of sanction regimes nationally, regionally, and internationally, this question becomes, I think, more and more pressing, is how to give precedence, to your national judgments producing the title to get a grip on these assets which are frozen. Thank you.
Two quick questions over here. Oh, we'll take those, and then I'll let our panelists respond, and they're going to do it incredibly briefly.
Yeah, hi, I'm Debbie Lapravat, and now with the Century. I was wondering, do we see more flexibility or cooperation coming out of the UAE? Because with my investigations now in Central and East Africa, everyone is offshoring their money in Dubai and Abu Dhabi and buying properties and banking there. And I'm just wondering if the international community is starting to receive more cooperation in asset recovery and freezing and identifying and repatriating assets from the UAE.
Good morning, Robert Thomas, and I'm an anti-corruption reporter for MLEX. Question stems from Ms. Butler's comment about the scrutiny of forfeiture, but anybody can answer it. That scrutiny is often framed in local asset forfeitures, deputy sheriffs on a very, very local municipal level, taking cars and things like that. So the question is what kind of political pressure, legislative pressure, are you seeing at an international level for this burden shifting? It's, like I said, it's been very well reported at the local level, but any comments about the international level, and also how might it affect private civil asset forfeiture cases, like the case in Paris for Obiang, those brought by NGOs? Thank you.
Thank you. Emile, may I start with you and have you just walk down the panel? You can take any questions. You have about 30 seconds to respond. I know, how terrible is that? And Ambassador, I'll have you be able to give us the last word.
On the first question, so what are PEPs doing if it becomes more difficult in financial centers? I think one of the issues I didn't mention in my comments this morning, but which we're trying to bring to the attention of the FATF is the control by politically exposed persons of the financial sector in their own country. And the ability of, and we've seen that in many of the Arab Spring countries as well, where basically they used a certain part of the banking sector as their own piggy bank, essentially. And I think that's something that we're still struggling with. And, you know, that goes to independence of supervisory regimes and things like that. I mean, there's a whole further discussion to be had, but I think that's certainly one. And then possibly an increased use of cash. Some people mentioned that, but that's more than my 30 seconds. Sorry.
All right, speed round. I think it's a huge mistake to be providing Iran with cash for anything. And the idea that we can't wire money in or find other ways of transferring value to the extent it's necessary for legitimate reasons is preposterous, in my estimation. So I've been through this at the Treasury Department and the White House, even in the context of North Korea, where the New York Fed actually played a role in helping return assets to North Korea. And obviously, North Korea, we don't have banking relationships in the U.S. So that doesn't fly. And I think providing cash is a prescription for disaster. Avenues, other banking centers, real estate is a major issue. Real estate investment, you're seeing in the UK a heavy focus on this, in particular given where kleptocratic assets are flowing. It's part of the reason why in the U.S., FinCEN, the regulator of the Bank Secrecy Act in the U.S., has issued geographic targeting orders for real estate markets where cash is used above a certain threshold to buy high-end property. That's now been extended from New York and Miami to the major markets in California as well as Texas. And so you should see more focus and enforcement on that front. And let me just say, Debbie's done incredible work with the Century looking at corruption in South Sudan and where those leaders have put their assets in places like Nairobi and elsewhere. So I think we have to look at regional centers when the major global hubs are blocked. Some regional hubs become the avenues of choice, and I think that's important. A final point on this, the market will drive, I think, cooperation with banking centers. You see banking centers that aren't able to articulate a theory of the case of their own transparency, having trouble with Western banks retaining relationships. This is the de-risking phenomenon. And so I think banking centers that become known for either blacklisted or known to be a haven for illicit activity really are going to not only find scrutiny from folks like Mary, be careful, but also from the market itself. And that's something to watch.
I'd like to take the last three in reverse order. First, with regard to the scrutiny on the asset forfeiture program, I think the problem that the department has acknowledged and has tried to address has to do really with administrative forfeiture. And this is what is happening when, in most instances, when local police stop people, seize funds, and then in order for the true owner of the funds to get them back, they must file a claim. And then that claim is litigated. But in a sense, it's viewed as burden shifting because the person has to file a claim in order to get those funds back. If they don't file a claim, they relinquish any right to that money. The department acknowledged that there were some abuses going on out there in America and implemented some reforms. So it's important for us not to bleed those criticisms over into the civil forfeiture arena, which is this extremely important tool that we use to attack illicit proceeds of all sorts. I know there's a sort of a task force approach to dealing with inquiries from Congress and legislative proposals to try to make sure that the message is clear, that there's a distinction between the problems that were identified in administrative forfeiture and the good work that can be done and is being done in the civil and criminal forfeiture arena. With regard to cooperation from UAE, you know, we're all hopeful all the time that we can, as they see the mutual benefit in cooperation with their world partners, that there will be more and more openings. In terms of this question about judgments and the enforcement of judgments, there's actually a whole lot of cooperation around the world in deciding whose judgments to enforce and in what order. We have a lot of experience with the Swiss and in this context. So it's not like bankruptcy where the first judgment in time, has certain priority, nor is there a clear rule about whether judgments can be enforced against sanctioned assets or not. It's subject to a lot of negotiation, and where we're working with countries who have the shared goal of repatriating the assets in a transparent and accountable way, the reality of whose judgment got enforced in full or in part becomes less important, and I think that's what we're experiencing, and that's terrific, and that's how it ought to be.
Final word.
Thank you very much. Before the final word on this very subject, I agree with what you said, even though if there is a sanction regime, criminal proceedings might be concluded both nationally or internationally in the framework of mutual legal assistance, but as long as there are sanctions, the money will stay on the account frozen. So, and there we have some issues, regarding due process when it comes to international sanctions, which is something that would require another debate. So I'm really glad to have been here this morning. I think we had a very interesting conversation. I will take a sentence that I think one said that, or it doesn't matter. Where there is a will, there is a way. That's what I think we should learn, both on preventing these monies from, leaving the countries they ought to stay and entering the financial circuits of developed countries, and there we might think of extending, deepening due diligence, requirements, or when it comes to taking action, and we discussed the shifting to administrative proceedings instead of criminal proceedings, preventive freezing, these kind of things, or when it comes then to the actual restitution. The idea being to let the population benefit from the money they were stolen of. I think that the key is first the political will to do so, and second, and I take your point. We will continue, talking to everyone. Is international cooperation. We have been at the G20 meeting in Beijing last year, I think, or this year. We will continue lobbying everyone. We will be at the G20, at the OECD, in international fora. We will talk to our bilateral partners, like-minded and not, because you also need the non-like-minded on board, to try and make what we have been trying and doing these last 20 years a general policy around the world.